I'd like to welcome you to GDPR in Practice, Future-Proof Data Management. We want to give you today some more insight into GDPR and how we can help you with this topic. My name is Ralf Steinemann. I'm the CEO of iTernity. And here with me is Mr. Werner Bachmann from Friedrich Graf von Westphalen to give you more a legal background to this topic. And I'd like to hand over to Mr. Bachmann.
Well, thank you very much for the invitation. It's a pleasure to be here, and I would like to share with you a few information about the basic principles on how the general data protection regulation will work in the future, and what the main impact and the field of actions are that have to be taken into consideration. Let's start with a view on the basic principles. The General Data Protection Regulation is something which can only be considered as a groundbreaking legal regime implemented on the scale of the European Union. It replaces a plethora of national regulations which share in common the unpleasant fact that they are all diverse. So the legal regulations which have been implemented in Germany do differ from the ones implemented in France, and the French ones from the ones implemented in the Netherlands. For all the enterprise and undertakings which are doing business in IT in Europe, it was close to a nightmare to deal with these divergent data protection frameworks. The General Data Protection Regulation brings that all to an end. We have a unified, a harmonized platform in law for the entire European Union. What you have to be aware of is that the regulation, due to its technique being a regulation, will immediately become effective at the end of May 2018. It will take precedence over the national legislation of each and any individual member state, and only where the member state, where the regulation grants the member states leeway and room for deviating national rules, they can do so. So in principle, it will be a strict European-wide regime controlled and supervised by European authorities. We had to deal with in the past in terms of how to enforce data protection rules with the fact that the major companies like Facebook and Google would not be easily be scared off by fines in the range of up to 500,000 euros. That was something they could pay easily out of pocket expenses. The data protection regulation will now bring that all to the standard level of European competition regulations. So at the very end, any infringement of European data protection laws can be fined up to 20 million or 4% of the global group turnover of the respective group of enterprises. And the higher value will always be decisive. In addition to that, not only the material, but also the consequential immaterial damages must in the future be reimbursed if any data protection law has been breached. So civil liability and damages will be going up considerably in the future. Overall, the extended liability in terms of fining by authorities and also higher damages that can be imposed in civil action will not only apply to the data controller, but it will also apply in any outsourcing regime for the data processor. Let's move one step further to the impact and the fields of action that have to be taken into consideration. Let's start with the duty to have a proper documentation. It is one of the ongoing responsibilities for compliance and risk management to have proper documentation in place. This is nothing new. The new thing is that it also applies for the data protection field. You have to document, you have to identify, and you have to make up your mind about transparency, about the legality of the processing of your personal data, about any question of data minimization. Did you take all the necessary steps that the data which are processed can be reduced to the minimum level which are required for performing the respective business processes? Did you implement any safeguards for the accuracy and the security of the data which are stored in your systems? Have you made up your mind about storage limitation? How long can you store these informations? And how did you secure the integrity and the confidentiality of the personal data requested, stored, and processed? Furthermore, take into account this is not only duty for the controller, this is also the duty for the data processor. So any outsourcing regime has to take into consideration to implement these obligations as a part of the core piece of the outsourcing contract. As I said before, data protection will be in the future a part of an adequate risk management and compliance regime in any undertaking. You're well aware that risk management and compliance is not only a matter of the lower ranks, but it's CIO and CEO task to comply with these obligations. So you have to make up your mind on impact assessment, what kind of sensitive data are requested, what kind of personal data are stored, processed, and transferred. You have to have a proper impact assessment in place. You have to make up your mind about the probability, the likelihood of any infringement, the likelihood of any potential risk, and what could be the economical and non-economical impacts of any of these infringements. You have to document and decide on adequate measures to secure the data which are processed. You have to implement your guarantees, and you have to document all the procedures to mitigate these risks. One of the specifics of the data protection regulation in this newer setting is that it's not only a matter of documentation and of how to define the business process, but it's also a matter of how to design and how to manage and how to operate technology. The keyword in that respect is privacy by design. You have to design all your systems, you have to design all your IT processes in a way that the data protection principles are effectively guaranteed and performed. The IT systems must be in the standard, in the default, be configured in a way that only the very minimum of rights and accessibilities are granted. Privacy by design. And all these design considerations have to be implemented as a part of the development process. So it's not a matter of after sales, it's a matter of the architecture, of the developing, of the construction of any of these products, services, or applications. It can be watered down a little bit by bearing in mind that the state-of-the-art requested is not the state-of-the-art, notwithstanding the costs, but only to the level of the implementation costs must be reasonable, must be adequate. But that's not a very big loophole. Please consider that state-of-the-art of the technique is the thing requested. When we have to deal with personal data in masses, operated, processed, and used, these operatings and these processings are not a one-time undertaking. You have to bear in mind, and so does the data protection regulation, that data must be portable. So any customer must be free to decide on whether his insurance company has to be changed, whether he's not willing to longer be with the bank he used to be, or whether or not he will stay with the hospital and clinic where he had his surgery, but decides to move on to another provider of such services. Data must be, by definition, be portable. And that means that the undertaking which requested the personal data, which processes the personal data and uses it, must have the safeguards in place that it can transfer all the data to the new destinations identified by its customer. Interoperability is the word of the day. You have to have it transferable. The only exception to that respect is you must not disclose any trade or business secrets to enable that, and you have not to disclose or transfer or to infringe any intellectual property rights which were related to that. Besides that, exceptions and exemptions, you have to have interoperability in place. The next point I would like to address is a critical one, and it had an immense uproar caused in the making of the regulation. That is the right to be forgotten. Data portability and right to be forgotten are somewhat rights that go together. If you like to change the hospital, if you like to change your tax provider, if you like to change your bank you've used to be in contacts with, then it's not only a matter of portability, but also the question that has to be addressed: can I request from my previous provider that all the data may be cured, may be deleted from its internal systems? Typically, it's an undertaking and an enterprise technically which is close to impossible. Imagine a hospital with something beyond 185 server systems, data management systems, archive systems, and things alike. How can you guarantee that if you decide to withdraw your information from such provider, that the deletion is perfectly applied to all the subsystems? But that exactly the task which has to be performed under the new regulation. If your client, if your patient, if your taxpayer decides not to be in any further contact with you and instructs you to delete, you have to delete. The only exemption to that is if you are requested by law to archive any such data. But beyond that, you have to delete it, and you have all the mechanics in place that you can perform the tasks of deletion if the client requests and insists on his right to be forgotten. The next step brings us back to the general question of risk management and compliance. Risk management and compliance always ask for transparency. So information, communication, and transparency are the minimal requirements for any adequate risk management system. So it is in data protection areas. In addition to that, please bear in mind that for the future to come, you have to notify and report all infringements of the data laws to the supervisory authority. And that's not only the case if, in fact, a violation is present, but also when the pure intention or the pure indication is given that a breach may have occurred. If the purpose of processing the personal data changes, then you have to notify the person whose personal data are concerned. And you have to make it in a very transparent way. You have to identify the connection between the original and the new purpose, and you have also to address the possible consequences. However, the new regulation makes it a bit easier that you can use personal data for big data purposes. You have to implement for such big data further or extended use, extended purposes. You have to bear in mind that you have to safeguard against any risks by means of to be in line with reasonable expectations of privacy. You have to address the possible consequences, and you have to have the technical safeguards in place and the appropriate guarantees that these safeguards will work effectively. If there is no other way to use or to make use of the personal data, you have to resort to anonymization or pseudonymization to use such personal data. Data exchange within the group of companies is a pretty nasty area for the data protection laws because in general it is impossible. Data protection law considers any member of the group, each and any member of the group, as an independent undertaking. So you can only transfer any of these personal data if you have the instruction and the consent of the person concerned. In the future, beginning at the end of May 2018, you can, within the group of data, transfer such data unless interests, fundamental rights, or fundamental freedoms of the data subject are concerned. That means, in general, you can do it, except the transfer of the data within the group of companies exposes the person concerned to new risks. So if you stay with a proper safeguard, a proper risk management, and maintains, and you're able to maintain this risk assessment, risk management, then you can transfer the data within the group of companies. This is a big privilege, and this is a big step forward.
Thanks, Mr. Bachmann, for this explanation of GDPR in general. We'll now like to give you some practical insights regarding implementation and how we can help you to solve the GDPR issues in your company. If we have a look at the real world and perfect world, so we see in our project that in a perfect world scenario, as we've learned now, all data should be managed centrally, maybe in one application. All data is classified. You're aware of what is personal data, what is not personal data. All data loss or data breach is automatically detected. Even the reporting is available with one single click. You get all information you need from personal data. All systems are always state-of-the-art. So this is a perfect world scenario. In the real world, we see it a little bit differing from this perfect world scenario. Most customers have different data sources, different applications in place. Only a part of the data is classified. A data loss is difficult to define or even to detect because a reporting, especially of unstructured data, is not existing or very complicated. Reports only capture classical ERP systems or shop systems or a DMS, document management system, and it's not group-wide or company-wide for all data. And there are many old systems still in place. It's maybe homegrown software or discontinued software without support agreements. So there is definitely a gap between perfect world and real world. The size of the gap depends on the company, to be honest. What we see as a practical step to the perfect world scenario and getting rid of the reality today is you have to be aware about all contracts that you have in place with service providers, and you have to be aware that these are GDPR compliant. All processes with personal data has to be documented. You should store your data in a searchable and indexable way to identify easily and classify data. Data classification should be happen. If you're not certain if it's personal or not, you have to treat it as personal data. So all personal data should contain also a kind of expiration date, so a kind of retention management should be in place for this data, so that you know when you have to delete it. Encryption is also important, and integrity protection has to be monitored, and the access to these data has to be restricted to only a few people or a few applications, and you should get rid of all systems that are not under support anymore. How we fit into this from our perspective as iTernity, we see a huge benefit in implementing an archive backend, including a retention management, so that it's much easier for you to solve all these GDPR issues in your company. Because if you have the data in one central place, it's easy to implement retention management, classification, deletion, and data transparency. Many requirements are easier to fulfill with the central data management. And as a software-defined solution, what we are, it's easier for you to participate in the technology development that's ongoing. So you can easily go from an on-prem to a hybrid cloud or to a cloud environment and get all the advantages of this technology development. From a company perspective, as iTernity, we have certified our solution regarding security by design and privacy design, and we've learned some minutes ago that these are some key facts of the GDPR regulations. This certification was done by KPMG, so all our products fulfill all these demands. And from a company perspective, we are also 100% GDPR compliant with our internal processes. And with a software-defined privacy, what we can provide to you, you have the highest flexibility for the future. And we have a lot of experience in more than 800 compliance projects, from small to very huge customers, from national to international customers. If you have a deeper look in how we can help you from a technology standpoint, what is the technology behind it, why it's good for GDPR, we have an own CSC, content storage container technology, we call it. It's patented from our company. We use it since years. The main technology is that we combine the content, so the object or the document you maybe like to store, like for example a CV for somebody who applies to a job for you, together with the meta information. This means any kind of meta information, including retention time, how long to keep it, etc., is stored together in one single object, is encrypted, has a hash value around it, and is so also integrity protected. All access to the CSC file is locked with our solution. Normally the access goes via your leading applications. We have integration with more than 100 leading business applications at the moment. So this technology gives you the advantage that even if you change the location of all data over the time several times, like on-prem, different technologies, maybe NAS device, SAN device, cloud storage, whatever, all the data stays protected. So it's a combined object, meta information, and content itself. Gives you the security that you can move data around without losing the compliance behind it. If you have a look over the time, we see that over the years in companies, technology is changing a lot. Also applications changing a lot. The only part that is still constant is the data you have to keep. In some cases, we have customers keeping data for more than here shown 30 years, like 100 years maybe. To be honest, we don't have a customer that's using our software since 100 years, because 100 years ago there was no software available and even not an operating system. So, but the customers with the longest retention period we have today are normally churches, to be honest. They have to keep the data, in their own opinion, forever. let's summarize what we've learned today. We have learned that GDPR is a big challenge and also an opportunity, because a lot of software or internal IT projects can now maybe get some speed on it, because there is now a budget for it, maybe because GDPR is putting pressure on this topic, and an immediate and systematical action is really required. You have to act now. Data management is definitely a very important topic of GDPR. So GDPR will drive a lot of database methodologies in companies, and a central data management platform is definitely an advantage in the point of GDPR to solve this issue right in your company. From an iTernity perspective, we can help you with our KPMG certified secure platform for data archiving and data management, including the retention management, providing user privacy by design and security by design aspect out of our solution, including the matching audit trail for everything and integration into your business application. So I would like to thank you for your audience, and thank you also, Mr. Bachmann, for your time. If you have further questions, we're more than happy to answer this.